you get between a mama bear and her cubs, and you're in trouble. All right, so welcome everyone to the next episode of Beneath the Law. Gavin Ty here with my good friend, partner, Stephen Teal. Stephen, great to see you again.
Nice to see you too, Gavin, and to hear your sweet voice.
My dulcet tones, as they say. Today we're really going to get ourselves into probably some hot water and trouble because there's really no safe haven in this particular area, which is probably the most populated minefield of our day, which is in relation to gender identity and those types of issues. And we really see that coming to the fore in Canada in respect of policies of at least two provincial governments in this country that have enacted policies relating to gender identity and children, and the role of schools and parents and the interplay of who's to know and who's not to know, and who has the rights and who has the responsibilities. And wow, if you want to get into trouble with somebody, have an opinion on any of this, because you'll find someone to disagree with you.
Look, I think, Gavin, what's really important is our podcast is called Beneath the Law, and this is probably the hottest topic in Canadian politics today. Is also becoming a bit of a hot topic in the United States in some respects as well. We haven't quite seen an articulation of it in the same manner. But these are legal issues, they're political issues, and I think our podcast is about digging into issues just like this. People will have various opinions, they'll have passionate opinions about it, but it is a legal topic, and so we've decided to talk about it, and I think that's fair game, and I think it's important to have a discussion on this topic, both from a legal perspective and a political perspective.
Right. So let's put on our Kevlar suits and we'll get right into it. So the backdrop of this particular episode comes out of where we're standing today is a recent decision that came out of the Saskatchewan Court of Queen's Bench issuing an injunction. King's Bench. My apologies. Although that doesn't really matter anymore. The Sovereign's Bench, we'll just call it that. And so this relates to as I mentioned, the policies and legislation that have been enacted by two provinces, New Brunswick and Saskatchewan. Maybe you give our listeners a quick backdrop on those two provincial mandates, if you will, or edicts that have caused so much consternation among a certain group of the population.
Sure. So New Brunswick and Saskatchewan have recently adopted guidelines through their legislation, or that I guess is beneath the legislation of their education acts, to essentially mandatorily require children under the age of 16 to get parental consent when wishing to use different gender identity pronouns. So in New Brunswick, I think the policy is policy 713, if I remember the number correctly. And Saskatchewan has something like a 8-page guideline that they recently announced as well. So that's basically the backdrop to this policy that has created a lot of controversy with respect to parental rights versus children's rights, charter issues, particularly under Section 7 and Section 15 of the Charter, and to court challenges. So there is a court challenge in New Brunswick through I think the Canadian Civil Liberties Association, challenging the law there. And in Saskatchewan, an organization called You Are Pride challenged the Saskatchewan government's guidelines under its Education Act with respect to this gender identity pronoun policy that they recently introduced.
Right. So this is a really, really interesting and hot topic on even a more general proposition. And as I was thinking about this, I mean, we both have grown children now, but we both have had children raised, and the notion of what role do parents play in a child's life, what role does the school play in the child's life, and I was thinking about this. One of the things that was sort of flipping this around, the notion, and those who were adverse to this policy were saying, well, look, there are situations where we have children, and they are children. If you're under 16, you're a child, as far as I'm concerned, and who have decided that they, wish to identify as another gender, and that decision of the child would not be accepted at home, and that therefore, if the school were required to advise the parents, that could endanger the child home life. So you may have a child who is identifying as a different gender at school, for example, but their parents know nothing about it. And these policies would have required, if you will, the school to reveal that, look, that your child, I won't say son, daughter, is identifying themselves as another gender at school. They want to be called her or what have you, or him, or whatever. And they required to tell the parents, and that would endanger them. And so the school was of the view that it would decide when and if the parent would be advised of this. It's a pretty interesting concept. And as I was thinking about it from a legal perspective, and the law always takes into account sort of two, in a very broad strokes way, things in all situations, which are rights and responsibilities. So, with rights go responsibilities, and conversely. And so, it was curious to me because, when I was, it's been a long time, it's hard that I can remember this, but when I was in school, and when my children were in school, I remember getting things called parental consent forms. And when a child was going on a field trip, for example, I'd have to sign a consent form that would waive my rights and permit that child to go off on the field trip, because if I had the right I was the guardian of my children, and I could therefore relieve the school of their responsibility with respect to that particular activity. So there was, to my mind, with every parental consent form for a field trip, an affirmation that the parent had the right, and, if I didn't want my child to go, I'd say, no, child's not going on the field trip, and I had that right to refuse it. But the school was concerned, if you will, that they wanted my consent to that, because I take it they didn't want to have the liability if something bad happened on that field trip without my consent. So square that complete notion of rights and responsibilities in that context with the rights and responsibilities to inform the parent about what's happening at the school and get their consent to this activity.
Well, I think, Gavin, that's an interesting question, because we know also at law, a person under, I think, the age of 18 or 16 can't enter into a contract. Right? The only time that's permitted at common law is where it's absolutely necessary for the underage person to enter into the agreement. So our notions developed through legal precedent would not permit a child to enter into a contract. And here what we have is children basically trumping a parent's rights with respect to what is potentially one of the most significant issues that they can ever make a decision on with respect to their identity. And, I was thinking about Toronto District School Board actually has a policy that would prohibit a teacher from actually going to a parent to tell them as well that, by the way, your child is identifying as a different gender. And what I find actually quite, I'm going to say remarkable, but I guess maybe that's the wrong word, interesting, is that in this decision from King's Bench on the injunction, there was a recognition on the applicant seeking the injunction that parents do actually play a role, and an important role, when a child identifies with a different gender than their biology is, right? So to preclude parent involvement doesn't, to me, make a lot of sense. Just from an overall legal perspective. And, look, the law advances with respect to the way society changes. But certainly for many people, it's foreign to not have parental involvement at all and parental consent.
Well, yeah, I mean, I think that's really, it's so difficult to understand. Now I heard an example. And this the takeaway on this is often, and this is why I said these issues are so charged, because oftentimes when people hear contrary viewpoints to their own view of the particular situation, they get quite upset and immediately would say that anyone who is, for example, anyone who is adverse to this policy or to this adverse to the school board's decision not to tell the parents, some people would say that, you're transphobic or you're homophobic or what have you. But I don't know that that's necessarily. On the other hand, I don't know that that's necessarily so. As you point out, children are in a very different position than adults, in the sense that adults are free to make whatever decisions that they may want to make and decide their own fate. But we don't do that with children. As you pointed out, a child's contract is not enforceable in the sense that a child's bargain or promise, a child's decision in respect of a bargain or a promise, is not something that a court can turn around. It is voidable at the instance of the child. We don't hold children to their decisions. We don't hold children to their bargains. And that is why we have this, I think, concept of guardianship, or we require parental guidance for various things, because children, generally speaking, aren't capable of making their own decisions about most things in life. Is that a fair statement?
Well, look, I look at it from the political perspective, and what I find absolutely fascinating is, can you point out to me any province in this country or any government that allows anyone under the age of 18 the right to vote?
Well, why not? If you're capable of making the momentous decision of what your gender is, that's a pretty momentous one. Why wouldn't you be capable of making the decision who should govern?
Well, precisely, and I think that's my point. And so from that perspective, there are inherent contradictions with respect to the positions that are being advocated by certain interests. Now, that's not to say, Gavin, that there are certain health consequences with respect to individuals who feel misidentified and who struggle with those issues. And I think those are very real concerns. It was certainly the biggest concern of the judge deciding the interlocutory or temporary injunction that has prohibited Saskatchewan's policy from taking effect, that there is irreparable harm in his view, based on the evidence that was led before the court. And, my understanding of reports is fairly consistent that folks who feel misidentified, children in particular, who feel misidentified, certainly have higher rates of suicidal ideation, and that being allowed to identify as they feel that they should be identified decreases that based on the evidence that was led. And, I can, understand that. Certainly, when I went to school, Gavin, a similar period of time in terms of going to high school, there weren't a heck of a lot of, certainly from what I can recall, there weren't a heck of a lot of kids committing suicide in our high school. But it's become certainly a much more problematic. There's lots of stresses that I think we put on children. University first-year students in particular, and lots of suicides at universities. We hear about that. So it's a real issue. I mean, let's face it. Those things are very challenging. They're life decisions, and where is the balance? And but like I said earlier, it's interesting to note that both sides express the view that parents do need to be involved. So where is the potential compromise? Now, what I want to indicate, just backing up a little bit, is that the New Brunswick policy seems to be much more watered down, or at least watered down versus the Saskatchewan policy. And that my understanding in New Brunswick is that New Brunswick's policy certainly permits professionals such as psychologists or social workers to identify with a child by their pronouns of choice without requiring parental consent. And that's certainly not, as I read the Saskatchewan policy, part of their policy. So there are some distinctions between the two policies, and New Brunswick has certainly moved in terms of compromising from that perspective. But from a political standpoint, you can certainly see, a government wanting to listen, I guess, to the public or the majority of the public that parental consent is always required, and there'd certainly be legal backing for that kind of a position.
So before we go on any further, I think that for the purposes of our listeners, and particularly those, again, who aren't lawyers, let me put this in a little bit of a framework in regards to the legal process that was involved here. So we've talked about the fact that the Saskatchewan government had a policy requiring parental consent to the change of gender or use of pronoun, or example, by a person under the age of 16. This group, You Are Pride, sought to intervene in that. You Are Pride was a group that focused on sexuality and gender diversity. They were accepted by the court as an intervener. So what they did then was they challenged the Saskatchewan government policy under the charter. As an interim measure, while that challenge is pending, and there's going to be significant hearing about that in the future, but as an interim measure, they brought an application for an injunction. And an injunction is an order by the court that suspends the operation of this particular policy. There's all sorts of basis for injunction. An injunction enjoins some party from doing something. The court, in that regard, applied what is the standard three-part test, which was set down by our Supreme Court of Canada in a case called R.J.R. MacDonald many, many years ago. But it's applied in every injunction everywhere of all time. So the three-part test really, there are easy parts and hard parts about getting an injunction. So the standard three-part test is, A, was there a serious issue to be tried? Nobody argued about that. There's no argument that there's a serious issue here. There are arguments pro and con on both sides of this issue, obviously, as the vigor of the debate testifies to. So no one was arguing about that. Where the rubber hits the road, if I can say that, on an injunction is this notion of irreparable harm. And what the court is looking at in terms of an injunction and whether an injunction should issue. And courts, injunctions are hard to get, and they should be hard to get. Courts are not inclined, generally speaking, to step in there and stop parties or governments from doing things unless there is some serious harm that frankly cannot be undone. And that's what irreparable, as the word suggests, harm is. Irreparable harm is harm that cannot be repaired later. It can't be fixed. It's done. It's the type of an issue that, it is literally a life and death, often type question. And that's really what was argued here, was that the implementation of this policy was a life or death proposition for children who were being misidentified in their preferred gender. And there was a significant amount of evidence led that there were increased suicide rates in children who were being misidentified, who were being identified as a gender that they didn't identify with, or that their preferred pronoun choices weren't being respected. There was an enormous amount of evidence about that. I mean, many people will have different views on that evidence or what have you, but the court was really faced with that issue. And then the final part of the test was the balance of convenience. And I think that, in fairness to the judge hearing this in first instance, there is a challenge pending. This issue will be argued in the fullness of time on a fulsome record in regards to the charter issues. And what the judge was basically doing was putting a hold, if you will, on the implementation of this policy until that charter issue was adjudicated. I think it's scheduled to be heard in the next few months. So that's really the legal framework of this. So it's the irreparable harm. The court found that there was sufficient evidence that there could be irreparable harm if this policy was implemented, and I think that's where we were getting at before. So I think our listeners need to understand that that's really the legal backdrop of this entire decision and where we are right now, which this decision just came out, shortly before our recording of this particular episode. So when you're hearing this, the final constitutional challenge may have occurred. But where we are right now is we're at an interim stage with this injunction issuing. And that's really it. So there was a determination that implementing a policy that required parental consent to children changing their pronoun could cause irreparable harm to those children. And what the court stressed, I think, and all parties said, was this is a minority of the minority, I think, if I quote the decision correctly, in terms of the children that could be adversely affected.
That was actually, as I understand that line, Gavin, and that's an interesting line, was the submission of your Pride's lawyer that there was an admission that the impact was on a minority of the minority. So, it's a noteworthy comment. I'm not sure if I was a lawyer that I would say that.
It's a powerful comment.
Absolutely.
I think the argument, and I think this was a well-grounded argument and a well-thought-out one on the part of the lawyer for UR Pride, in the sense of getting this injunction. I think their argument would be, one child is too many. I mean, the argument would have been if one child, takes their own life because of the implementation of this policy, then that's irreparable harm. I get my injunction. And if there's a real possibility that might happen, I've met the test for the injunction. That's, I think, what the minority of the minority argument really is. And frankly, from an advocacy perspective, a brilliantly executed argument.
Granted. The other thing, Gavin, that struck me, and the judge doesn't raise it, but one of the principles of injunctive relief is to maintain the status quo. And I think that, too, was a very good argument that was made by UR Pride's counsel, indicating that if we implement this policy, we're undoing what has gone on before, and that there would be children that would have already been, quote, they use the term social transitioned, and now you may be undoing that. And so in the weighing exercise, maintaining the status quo was certainly, potentially in the mind of the judge as well.
Yeah, I take that point. I think it's interesting. When do you determine the status quo? I don't know when the prior policy of don't tell the parents happened. I mean, and I've heard other people put this in a different context. I don't want to be clear about this. And people who have been in support of the injunction being issued have put it a different context of this outside of the gender identity context. Let's say, for example, their example was, well, let's say you have a young female student who is wearing a hijab and then comes to school and takes off her hijab. Do the parents have an obligation to tell the parents that the child is taking that off during the day at a public school?
A very good question.
Well, should they? I mean, should the teacher actively then phone up the parent and say, your child is removing their religious head garment? Is it possible that could lead to serious potential repercussions for that particular child? Is that harmful? I can see the argument. I mean, I could see the argument in various contexts, but I don't know. It really comes right back to the point again. It's an awful lot of responsibility if you're going to give the school the right to make that decision without the involvement of the parent. When we're talking about children who don't have the ability to have their decisions enforced legally, and in many other contexts, as you point out. I mean, what if the school is taking that right? What responsibility does it give the school?
Look, Gavin, those are very important questions. I'm not sure that I have a ready answer with respect to any of that. No, well, of course not. But that's making my brain sometimes work way too much. Look, the religious issue is certainly one. I think it's. I would draw a distinction with respect to the gender identity issue. I'm not sure that there are necessarily health consequences with respect to the religious issues. There could be. Well, absolutely.
We've had cases where children haven't been given proper medical care because it was against religious belief. Is that what's the situation there? Should there be an injunction that they get it? I mean, there was one case where a child was denied chemotherapy because of that. I mean, there are other cases where the child was being treated, I believe it was for meningitis, with herbal remedies and died. And the parents were criminally charged.
Well, and there's an interesting case that was just issued by our divisional court with respect to, parental involvement with respect to vaccinations and the COVID-19 vaccination, and that was persuasive of the court with respect to custody of the child. So, look, there's lots of challenging issues, which is why this issue in particular is not just legal; it's also political.
Well, that's really where we're going with
right.
this.
And so let's take a look at now the reaction of the Saskatchewan government to this temporary injunction that the Premier of Saskatchewan has threatened or doubled down that he wants now to invoke the notwithstanding clause under the Charter to basically stop in its tracks the Charter challenge. Because the Charter challenge is brought under Section 7 and Section 15, the notwithstanding clause of the Charter permits a government to invoke the notwithstanding clause that would override Section 7 and Section 15 rights.
Right. So that, this is an interesting Canadian constitutional issue. It's much different than the United States in this regard. And it came about, and people always say, well, you're throwing the charter out the window by invoking the notwithstanding clause. Let's not forget, the notwithstanding clause is in the charter. You're not throwing the charter out the window by invoking the notwithstanding clause. You're actually relying on the charter. And arguably, there would be no charter in Canada unless there was a notwithstanding clause, because the notwithstanding clause was the compromise that led to the charter being put in place in the first place, and the consensus among the various Canadian provinces, except for Quebec, that led to that, which was the primacy of Parliament, the primacy of the democratically elected government over the rights-based rule of law decisions of effectively unelected judges who make decisions under the charter. And that's really the balance of Canadian federalism, of the Canadian Constitution, really rides on the Section 33 issue. And just one of the key points that I always like about Section 33 is the time limit, which is that every government's got to go back to the electorate in 5 years and run on it. So if you invoke the notwithstanding clause, it's got to be reviewed again. That legislation must be reviewed again in 5 years, which means the next election cycle will have happened. So governments wear it. The notwithstanding clause is by design got a political time bomb baked right into it, that when you invoke it, you have to be prepared to stand behind
it. Right. It has a sundown feature to it. But look, the reality is that it exists in our Canadian Charter of Rights and Freedoms. As you clearly articulate, it was a compromise in order to get the Charter of Rights in the first place. And what I always find fascinating, Gavin, with respect to the government's threat, we call it a threat, to invoke Section 33 of the Charter, is that it always leads to the reaction that, well, you can only introduce it in an emergency. That's not the language, and that's not the case. There's nothing, as far as I have ever read, that's to suggest that the notwithstanding clause could only be used in an emergency situation. So that, to me, is that argument is a myth.
Yeah, no, legally you could use it for every decision that ever was. But I mean, I think the point, my point of my 5-year clause is there is a political price to be paid, and a political toll, if you will, to be levied on the use of the notwithstanding clause. If the government, and in this case, if the Saskatchewan government does pull the trigger on this, they must feel that a significant percentage of the electorate would stand behind their position on parental consent.
Well, look, I think the reality of the politics is this. Saskatchewan right now is very much a conservative province. All of its federal seats are conservative. What is happening at ground level in Saskatchewan is that there's a challenge to the current government, the Saskatchewan Party's government, from the right of the political spectrum, the more conservative side. And they're beginning to take on these issues of basically listening, to the majority and taking positions that are attractive to the majority, and it's eating into the popularity of the party. And so I think politically there's a concern from the party's perspective, from Premier Moe's perspective, that they need to take positions that will, cater to certain organizations, whether they be religious-based organizations or other cultural organizations. I mean, look, Gavin, I think Canada needs to face a real reality from a political perspective. We are a cultural mosaic. And within that cultural mosaic, there are certainly groups that have values that are different than a much more liberal society. And that is always, I think, a very, very difficult tightrope to walk. And when these issues come up, governments have to react in real time. And so they adopt policies, and I'm not going to get into the merits of the policy. I mean, I have my own views on that, but look, I don't want to be labeled one way or another. I get very concerned with respect to labeling. So they're reacting in real time, trying to figure out what is the best solution. And like I said, when I look at the decision, what really stands out to me is that both sides agree that parents have to be involved. And so from a policy perspective, how do you best get there without aggravating both sides? And what is the compromise? What makes sense? Certainly if when I think about my own children, I don't want the school keeping anything from me.
Yeah, you know what? This is really a larger issue, and one that's really hits people quite close to home. There's few things that I don't think there's anything people care more about than their children, and then their children's well-being and their children's future. And you're unless there's something wrong with you as a parent, that is your prime concern, and is the dearest and nearest thing to your heart. So it's an incredibly emotional and evocative topic. So in a general way, the role of parents and the role of the state, for lack of a better word, or institutionalized public education in the raising of children is a huge issue. And there are all sorts of societies we could go through across the world where many autocratic regimes, for example, would like to remove the parent and the family from anything to do with raising children. I could think of a few particularly despotic regimes in history that have sought to do that. So there's a real tension there. Parents you get between a mama bear and her cubs, and you're in trouble. And that's an instinctual thing.
Well, look, Gavin. Gavin. The rights of parents. I mean, we're here in Canada. We've just recently celebrated, Every Child Matters, because children were taken away from their parents in our Indigenous communities. So it strikes at the core of all parents, and it's foundational. And so, from a political perspective, you can definitely see where the Saskatchewan government is coming from, because it's such an important issue at its bedrock.
What an interesting, I think, analogy of the state-run attempt to remove parents and families from education, and probably one of the most egregious examples in history anywhere, the residential school system here in Canada, where basically that was the whole ethos behind it. The ethos was, we know better. These parents should not be involved in these children. If we completely remove them from these children's lives, these kids will be better off in the end. Now, it went horribly wrong, of course, in many, many instances. But was it horribly wrong from the start? What kind of ethos is that seeks to separate parents and children and remove parents from the raising of their children? Those are the issues that are at play here. I can see both sides of the argument, to be perfectly honest with you. But anyone who looks at these issues as sort of, I'm all right and you're all wrong, they need to think a little harder.
I think that's a wrap on that comment, Gavin.
I think it is too. So with that, we'll take off our Kevlar. Actually, maybe we should put it on for the comments section, which we hope you'll get, and we hope that you'll give us your thoughts and on this very important and evocative, as I say, topic. And Stephen?
And just before you sign off for us, Gavin, I think what's really important, and I hope that we've drawn it out, is that there was a legal procedure involved here, and how that legal procedure runs its course, and how it can cross into political issues. I think that's the key takeaway.
I couldn't agree more. So we have a political issue brought into court, going to be argued in court in the fullness of time, and then maybe taken out of court by another political issue, which is the use of the notwithstanding clause to basically evacuate any judicial ruling of the constitutionality of the policy. So with that, thank you so much, Stephen, again. Always a pleasure. And thank you for listening. We hope to see you again on our next episode. And remember, if no one is above the law, everyone is beneath it.